If you have to choose, should you hire an attorney or post your bond? This is Christina Williams with Just Criminal Law.
And David Mann, legal storytelling specialist. So, which would you advise?
Well, I would always advise that the person hire an attorney, and there's multiple reasons why I say this. So first of all, right out of the gate, I have an example of a case we just finished up. And this individual had a really high cash bond, and they had 8 serious violent crimes alleged against them, and they were stuck in jail. So their family had to decide, should we hire an attorney or should we try to post that large cash bail? And, they spoke with my team and decided we're going to hire an attorney.
All right, so they did the right thing, it sounds like. And what happened? I mean, how does this whole process start, and what were you able to accomplish?
Sure. So what happens is an individual will get a bond set at their initial appearance in front of a judge. And 9 times out of 10, they do not have an attorney present when this bond is being set. So the judge asks the prosecutor what they think an appropriate bond is, and they ask the defendant if they have anything to say. And, majority of the time, the judge is going to set the bond in the amount that's requested by the prosecutor. So sure enough, for our client, this is what happened. Now, after his bond was set, his family reached out to us and visited with us about hiring our team, getting involved in the case, and we decided to accept the case, and we went to the next court appearance with the client.
Okay, so you accepted the case, went to this appearance, and he's got how many charges against him at this point?
He had 8 serious violent felony charges against him.
So he had a very, very high bond, I'm guessing?
Yes, it was a very, very high bond, and we appeared with him and talked to the court about some investigation that we were able to quickly do. We talked to the court about the alleged victim and their position on the bond and pointed out a few inconsistencies in the police report and got the judge to agree to lower the bond. And so at the end of that hearing, he had 1/3 the amount of bond as he did at the beginning of the hearing.
All right, that's quite a reduction. Was he able to pay that one?
No, unfortunately, it was still too high to pay. And so we went on to the next stage and what we could do for the client. And we were able to negotiate with the prosecutor and get the prosecutor to dismiss 6 of the 8 counts. And we knew that the prosecutor was going to ask for a prison sentence still. And part of that plea deal included that we would be able to ask for something less than what the prosecutor was going to recommend.
All right, so what did the prosecutor recommend?
Sure. At the sentencing hearing, the prosecutor recommended a 5-year sentence, and we requested a probation sentence that is no more jail time and just place our client on probation. Now, he had already spent 8 months in jail, and so he'd spent a significant amount of time waiting to get before the judge for sentencing. And so our argument was, he served the 8 months, just put him on probation, judge, and you can put him on probation for an extended period of time, but give him an opportunity to get back out in the community, to become employed. And so, long and short of it, what the court ended up doing was sentencing our client to a split sentence, meaning he could finish out his time at the county jail. He ordered that he serve 1 year in jail, and he did not have to go to prison, which was a very, very good outcome for him.
Yeah, I mean, that sounds like quite a success story. So if I'm hearing this right, all the things that you and the firm did was to reduce his bond from a very high amount to 1/3 that, to reduce his charges from 8 counts to 2 counts, and then to reduce his potential sentence of 5 years down to 1 year, which effectively was only a few months plus probation. Is that the whole story? That's pretty good.
Yes, and so he ended up, needing to serve a few more months in jail, and then he was out on probation, and that probation period was 6 years, and he just needs to follow the law and, keep his nose clean, so to speak, and that's all the more jail that he'll have to do in the case.
Well, that sounds like that initial choice they made to hire you was the right choice. So how can others also make that same choice?
Sure, we'll include a link in the description where you can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.